I'd like to start by giving a very brief introduction to the exhibition and its background, and then we'll turn things over to Fred, who will discuss David Daggett and the first half of the exhibit, and then I'll come back around to the second half of the exhibit myself. And so I really wanted to start by talking about the exhibit as its own historical enterprise, and that it is based on longstanding research at the law library and the law school that really originated in part at the request of Teresa Miguel Stearns, who was the former librarian for the Lillian Goldman Law Library. And this current exhibition was created at the request of Heather Gerken, the dean of the law school, and Femi Cadmus, the new librarian for the law library. And it represents one of the contributions of the law school to the overarching Yale and slavery project. And so what you'll see as we discuss the exhibit is that this is really a deeply archival project, as is the Yale and slavery project overall. And so the exhibit, as it stands, draws on the collections of manuscripts and archives of the Beinecke Library, of the New Haven Museum, the Connecticut Historical Society, and really the work of our many generous colleagues who allowed us to do work in the collections and who provided facsimiles for the exhibit as well. And it is represented in this booklet, which I think will be, and the online exhibit, which will be the sort of ongoing permanent footprints for the exhibition. And so in the booklet that you see is obviously the work of one of my beloved colleagues, Rebecca Martz, in the Office of the University Printer. And so really the exhibit tells one story among many possible stories about the three founders and who those founders even, how they're even defined and what the relationship is with race and slavery. But it draws on this much larger and messier and inconclusive archival landscape that you can see Fred and I were trying to come to grips with in the context of this exhibit, which is contained within two cases. And so it's almost inevitably incomplete. And I invite you to come visit it. It's open to the Yale community on level 2 in the law library to see it in person. And I also hope that you'll come join us this Thursday for a tour of Grove Street Cemetery led by Mike Morand of the founders of the Yale Law School in life and death in the cemetery, which has its own place as a type of archive of New Haven. And so with that, I'll turn to Fred to discuss the first exhibit case.
All right, so Kathryn and I, in this exhibit, our goal was to present the historical facts and allow people to draw conclusions themselves. But I will, in order to frame the overall picture and help you get familiar with the three founders, I'll summarize as follows. There were three founders of Yale Law School: Seth Staples, Samuel Hitchcock, and David Daggett. Of the three, Staples was an active abolitionist. Hitchcock, we know less about his views on race and slavery than the others, but it appears likely that he was supportive of slavery. David Daggett, who was a major politician, he was a United States Senator, Chief Justice of the Connecticut Supreme Court, Mayor of New Haven. He's the one that was quite problematic in his connections with race and slavery, as you'll see, and a lot of our exhibit focuses on Daggett. Now we'll start off with, we're going to be showing images from the exhibit, and we'll start off with, you'll see in the lower right-hand corner here is a page from the 1800 United States Census for New Haven. and the names of people are listed, and there are columns with information like how many children they had, that kind of thing. And there's a column for slaves. David Daggett, all the way on the right-hand side in the rightmost column is a mark of the number 1. And that means that he had one enslaved person in his household. We also found in his papers at the Manuscripts and Archives Department of the University Library is a bill of sale for the rights to a man named Henry to David Daggett. That Henry's the rights to Henry were conveyed to David Daggett in 1814. So he had at least 2 enslaved people in his household. We know that. The next connection of Daggett with these issues is there was a book that was published in 1790, a pamphlet. It's rare. There's only a few copies known to survive. One is at the Beinecke Library. It's called Sketches of the Life of Joseph Mountain, a Negro who was executed at New Haven on the 20th day of October, 1790. So Joseph Mountain was a free Black. He was not enslaved. He was a free Black who went to England, became a sailor, and engaged in various criminal activities. He was arrested in Connecticut for rape. Historians believe that this was probably a false accusation, but he was executed before a crowd of 10,000 people in New Haven on the green, if you can imagine. 10,000 people watched his execution. There's a historian, Richard Slotkin, who has said that there was a literary genre of criminal confessions or biographies of Black people, which spread a myth, a stereotype of the Black rapist. And the story of Joseph Mountain clearly fell into that genre. And this book was one of the best-selling examples of this kind of confession. We'll go to the next page now, and this concerns the story of Prudence Crandall. I don't know how many of you are familiar with Prudence Crandall. I think she's not nearly as famous as she should be. But Prudence Crandall was the occasion for the most important things that David Daggett did in connection with racial issues. Crandall was a school teacher in Canterbury, Connecticut. She founded in 1831 the Canterbury Female Boarding School, instructing about 40 children. And she, at some point, was exposed to the abolitionist newspaper, The Liberator. This was the big abolitionist newspaper in the country, William Lloyd Garrison's newspaper. And this caused her to consider, quote, the manner in which I might best serve the people of color. Her opportunity to help people of color came in 1832 when Sarah Harris, the daughter of a free Black farmer, applied to her school. Crandall admitted Sarah Harris to her school, creating the first racially integrated school in the entire country. So her neighbors and the residents of the town of Canterbury were not happy about the integration of the school, and they began to withdraw their daughters. Crandall consulted with prominent abolitionists in Boston, and she proceeded to recruit other Black girls as students, which led to further defections of the white pupils. So in 1833, she closed the original school and reopened, this time establishing the first school for Black girls in the United States. That she reacted to the furor over admitting Sarah Harris by admitting more Black girls and making it an exclusively Black school. The Connecticut General Assembly reacted by passing a law called the Black, was referred to as colloquially as the Black Law, which banned the operation of any school instructing Black students from out of state without permission of the town. Canterbury continued its campaign against the new school as the old school, and really quite viciously harassed and committed violence against the school. I won't go into all the details, but they attempted to set the school on fire, and they poisoned the well of the school with animal feces. Crandall was arrested under the Black Law in July 1833 and jailed overnight. She had a succession of legal proceedings. She had 2 trials. The second trial was presided over by David Daggett, who at that time was the Chief Justice of Connecticut. And Daggett, in this trial, charged the jury, stating, quote, "The persons contemplated in this act," meaning the Black Law, "are not citizens within the obvious meaning of that section of the Constitution of the United States." By this statement, what Daggett meant, not only that enslaved persons were not citizens, could not be citizens of the United States, but even free Black people could not be citizens of the United States. So following Daggett's instructions, the jury found Crandall guilty. And the constitutionality, the defense tried to raise the constitutionality of the Black Law, but that was dismissed by Daggett because of his feeling that they could not be citizens. So Prudence Crandall appealed her case to the Supreme Court of Connecticut in 1834. There were 4 judges in the Supreme Court. 3 of them believed that the Black Law was unconstitutional, and they later said that after the Civil War. They said explicitly and wrote that they had wanted to find it unconstitutional. The 4th judge was David Daggett. So David Daggett was in the unusual position of reviewing an appeal of a lower court case that he himself had presided over. So there was a kind of a unusual conflict of interest there, but also he clearly exerted influence on the other judges and persuaded them not to challenge the constitutionality of the law. It happened that they did acquit Prudence Crandall on a technicality, but the important thing legally was that the Black Law stood. They did not question its constitutionality. 23 years later, after this Prudence Crandall decision, there was another case, this time in the United States Supreme Court. And that was the case of Dred Scott v. Sanford, which is widely considered to be the most unfortunate case in the entire history of the United States Supreme Court. And in that case, Dred Scott v. Sanford, this is how David Daggett had his greatest influence on issues of race and slavery. Because the Chief Justice Roger Taney of the US Supreme Court, in his opinion, he found that slavery, that citizens, Black people could not be citizens of the United States, and he found that slavery could not be prohibited in the American territories in the West, which was a very large issue at that point in American politics and culture. And in order to support this decision, he prominently cited David Daggett's words in the Prudence Crandall case. And many people believe, many historians believe, that the Dred Scott case directly led to the United States Civil War, that this was kind of the one of the things that kindled the fire that resulted in 1861 in the Civil War. Although that was David Daggett's leading impact, there were a few other things that he was involved in. First, let me mention Samuel Hitchcock. Samuel Hitchcock, the third of the founders, the least well-known of them. He, in his lecture at Yale Law School, he left behind, a student left behind a book of lecture notes of Samuel Hitchcock's lectures, which are in the rare book collection of the Yale Law Library. And in this lecture notes, according to the student who took it, the words that he transcribed show that Hitchcock did talk about slavery and and citizenship, and he parroted the words of his colleague David Daggett, repeated the same arguments that Daggett had made about citizenship. And now it's possible that Hitchcock was only summarizing the state of the law or repeating what his colleague had said, but it's notable that there's no hint of any criticism or disagreement in Hitchcock's words with the Daggett theories. In 1831, and these are the two final things that Daggett and Hitchcock were involved in. In 1831, there was a meeting in New Haven to oppose a project of founding a Negro college in New Haven. There were New Havenites that wanted to create the first college in the country for Black students in New Haven. There was a big meeting to oppose this. People said that the purity of Yale College would be corrupted by proximity to a Black college. And David Daggett addressed the meeting in favor of the anti-college resolution. The committee that drafted the resolutions included Hitchcock, and almost unanimously, the college proposal was voted down and it never happened. A second New Haven meeting in 1835 introduced resolutions calling for Connecticut abolitionists to be prevented from interfering with slavery in other states, particularly by distributing anti-slavery publications. And this meeting also advocated that free Black people be sent back to Africa. One of the names on the resolutions in the second meeting was David Daggett. So this is our display in the law library now has two cases. All the things that I've been talking about are in the first case. Kathryn is now going to talk about the second case, which focuses on Seth Staples and the Amistad case.
Right. Well, thank you, Fred. And so, so you see here the portrait of Seth Perkins Staples, and I want to say that one of the striking things about the exhibit is the fact that the founders' portraits are all by Jared Bradley Flagg, who was a Connecticut artist, and they you can see that they have a very similar style, and also mark the fact that Staples, Hitchcock, and Daggett were all commemorated at more or less the same moment. And the portraits are part of the Yale Law School collection and are hung around the exhibition now. So in our thinking about the exhibit, we decided to center the second case around Staples and the Amistad case, in part because it's such a famous case, and so much a part of the New Haven fabric. And one of the reasons I say that is that when you start to look at the archival holdings around the Amistad case, I rapidly came to the understanding that they're really centered with the papers of the various participants in the legal, in the case, in the collections around New Haven and around Connecticut as well. And so really the Amistad case in New Haven, you can find records in the law library holdings, in manuscripts and archives, in the Beinecke, the New Haven Museum, and elsewhere. And so in talking about it in this context, and I guess I'm tiptoeing around the fact that I feel a little embarrassed about even discussing the Amistad case, which is so well known within those archival circles and within historical circles. But it struck Fred and me that there's a particular aspect of the Amistad case that is the legal historical. And so what our exhibit really focuses on is it highlights the legal administrative aspect of the Amistad case, with which many of you will already be familiar. If not, the Amistad case centers on the ship, the schooner L'Amistad, which was towed into New London Harbor by the United States Coast Guard in 1839. It bore 53 captives who had been illegally enslaved by the Portuguese off the coast of what's now Sierra Leone. The ship had been taken to Havana, and then from Havana, bought by Spanish plantation owners, and were taken towards Puerto Principe, and then basically rebelled and seized the ship and tried to steer away, but were led surreptitiously by the remaining Spanish crew up the east coast of America, where they were then seized. And so the ship was towed into New London Harbor, and the case from the outset became quite notorious in the Boston and New England abolitionist circles. And so Seth Staples entered into the scene and into our exhibit when he was asked by Lewis Tappan and other prominent New England abolitionists to be one of the attorneys in the case. And so Staples, as you can see in a letter from Staples to Roger Sherman Baldwin, writes to agree to be one of the attorneys and represented the Amistad defendants in the first set of cases of the Amistad trials, which went all the way to the United States Supreme Court. And so because the series of trials is so familiar, I believe, to many of us here in New Haven and in the Yale collections, I wanted to highlight some of the aspects of the holdings that we had that were particular to this. And among these, you can see the notes that were kept by Roger Sherman Baldwin, who was the attorney who brought the case all the way through to the United States, to the Supreme Court trial. And you can see here in these tiny little notebooks, which are really, they're the size of kind of my iPhone, that Baldwin is here preparing his notes for the case. And so it's a way in which this case, which has had so many different stories told of it, so many narratives coming out of it, you can see that at the time, in practice as a lawyer, Baldwin is also formulating his case around what he hears from the different stories and the different testimonies at work. And so these notebooks are held in the law collections. And one of the covers, which are in the sort of blue waste paper that you can see here, he's drawn a picture of the ship L'Amistad that you can see represented here. And so one of the aspects that we highlight in our case is the way that the testimonies, the stories of the Amistad are in part created through this legal process, that they're given as depositions, that they're produced as evidence. And it's the documentation of these testimonies that really survives archivally in many of the holdings to frame the ongoing history of the Amistad series of cases as well. And so you have that moment of archival creation and survival that is shaping what we now know of the Amistad story and what is what is documented as an authoritative aspect of its history. And so with that, because that was really what was governing a lot of my thinking with this, I want to just close with two instances from the case that were particularly from the exhibit that were particularly striking for me. And the first on the left are 6 of these really profoundly moving sketches of the Amistad captives that were made by William Townsend. These are the originals are held by the Beinecke Library. I became aware of them in the course of my work at the Beinecke, listening to my colleagues and reading their work on these. And so they're shown in the exhibit in facsimile. But what is striking, I think, to me and moving and really in some ways disturbing about this is that the images are so powerful, and the names, which are shown phonetically of the defendants, are also in their own way commodifying the defendants through the trial. And I can say that because, you know, a New Haven artist also used the representations of the Amistad defendants as the basis for a series of wax figures, which were then exhibited in a museum in New York and elsewhere. And so you can see in some ways the ways in which the stories of the Amistad defendants achieved a life that was in some ways beyond their control. The visual representation of them, and then of course their testimony, which was translated from the Mendi language into the language of the court process in Connecticut. And so the image that closes this section of the booklet and the exhibit is drawn from the brilliant poet Elizabeth Alexander's work, her series of poems on the Amistad. And this particularly beautiful poem called The Yale Men, talking about the act of translation and its importance in the exhibition. And I'll just read it briefly. One by one, the Yale men come to teach their tongue to these caged Africans so they might tell in court what happened on the ship, and then, like Phyllis Wheatley, find the Yale men's God and take him for their own. And she's referring in such a powerful and interesting way to the act of translation and the production of these depositions, the translations of the testimony and production of these depositions that underpin the evidence that these defendants were giving in trial. And so you can see below this on the screen, the deposition by Samuel Hitchcock, this is his one moment of representation in the evidence surrounding the trial, where he is deposing James Covey, who was the translator for the Amistad defendants, deposing him to give evidence in the trial as well. And Alexander speaks about her encounter with the Amistad trial in a really interesting way, and one that I think is very telling for the exhibition. And that she talks about it in her work as having been, you know, walking with her child in a stroller past the New Haven Museum, and finding that it was open and going in and encountering the exhibit there, and being drawn into the archival record of this, and producing from that this really wonderful series of poems that she then published in her book American Sublime in 2005. And I think we decided to end the exhibit with this because it is one response, I think, to the request or the request that the exhibit focus on the idea of the archive as offering you know, an empirical form of evidence, of telling the facts as they are about these stories, when obviously, as Alexander's experience shows, the story of the Amistad defense is not over. And so the telling and retelling of it, the construction and perpetuation of these narratives is also something that somebody encounters, Alexander encounters in a museum, and is then drawn to her own engagement with those archival holdings and her own archival research and response to this. And so the exhibit, as we've framed it, is, you know, one rendition, one legal administrative, following one trail of documentation around these 3 figures. But it also shows, and I think highlights maybe interestingly, just how intricately embedded these 3 founders were with each other and with the broader New Haven and New England communities. And so, you know, in some ways, the exhibit frames this polarity, this binary relationship between Daggett Staples, and as we haven't really touched on, Hitchcock also has his own representation too. But that binary relationship is in fact maybe a false one, because as Fred pointed out at the outset, the three founders were intricately involved in working together in the law school that became the founding institution of the Yale Law School. And so no matter how you sort of create a binary or opposition, at the end of the day, these three founders, as others in the community, were very closely involved with each other.